Corporate death is never an accident. It is a meticulously regulated legal execution, governed by the Revised Corporation Code. This is Title 14 of the Code, the definitive statutory framework for corporate termination. The process splits down two distinct paths. First is the voluntary branch, where the corporation's internal organs, the board of directors and the stockholders, initiate the closure themselves. Second is the involuntary branch. Here, the state, acting through the Securities and Exchange Commission, forces the closure via a mandate or a verified complaint. Look at the text of Section 133. The law states a corporation may be dissolved voluntarily or involuntarily. There is no third option. The binary is absolute. If you are tackling a bar exam problem, your first step is always to identify the initiator. That single fact dictates which set of rules applies to the dissolution. A common trap is assuming the board of directors can unilaterally shut the company down. They cannot. A voluntary dissolution always requires the concurrent approval of the stockholders. Because dissolution destroys a legal entity, the state demands strict procedural compliance. As we navigate the code, you will see a clear pattern. The legal friction involved in closing a business scales exactly with the risk it poses to the public and its creditors. We start with the path of least resistance, Section 134. This procedure applies when a corporation has zero debts, meaning statutory friction is at its lowest. When no creditors are affected, closing the doors requires just a simple majority vote from the board of directors and a simple majority vote from the outstanding capital stock. The administrative hurdles are equally light. The corporation must give 20 days' notice, publish that notice a single time in a newspaper, and file a verified request with the SEC. This focused view of the codal text confirms the threshold. It explicitly asks for a majority vote of the board and a majority of the outstanding capital stock. There is one notable exception. If the entity is a bank or an insurance company, it cannot dissolve without prior clearance and a favorable recommendation from its specific regulatory agency. For the bar exam, precision matters. Under Section 134, the document filed is strictly called a verified request, not a petition. Do not fall into the trap of thinking a 2/3 stockholder vote is always required for dissolution. If there are no creditors, 51% is legally sufficient. The Revised Corporation Code simplifies the exit for debt-free corporations precisely because their closure poses zero risk of prejudice to third-party creditors. But the moment a corporation owes a single debt, Section 135 takes over. The presence of creditors transforms the process into a high-stakes legal proceeding. Look at how the voting mechanics escalate. While the board threshold remains a simple majority, the stockholder requirement aggressively snaps to 2/3 of the outstanding capital stock. The filing also upgrades from a simple request to a verified petition. Crucially, this petition must contain a comprehensive sworn list of all corporate creditors. Transparency rules tighten significantly. The SEC order must be published once a week for 3 consecutive weeks, followed by a mandatory formal hearing where creditors can trial their objections. The statute mandates these precise hurdles: 2/3 of the OCS, a verified petition, and the exhaustive list of creditors. In exam scenarios, watch for triggers like unpaid suppliers or pending labor cases. These facts instantly mandate the strict Section 135 procedure. A critical pitfall is ignoring contingent liabilities. If a corporation attempts a debt-free dissolution while hiding pending claims, the entire process is voidable by the aggrieved creditors. Section 135 acts as a procedural shield. It guarantees that a corporation cannot simply use its own death as an escape hatch to vanish with unpaid obligations. There is an alternative route. Under Section 136, a corporation can dissolve seamlessly by amending its articles of incorporation to shorten its corporate term. This follows the SAA mechanics. Shorten the term, amend the articles, and the result is automatic dissolution. This highlighted text proves that Section 136 operates by operation of law. The corporation is deemed dissolved without any further proceedings, meaning no final certificate of dissolution from the SEC is required. Take note of the exact timing. The dissolution automatically takes effect on the day following the last day of the corporate term. But what if the corporation changes its mind? Section 137 introduces the right to halt this legal suicide through a formal withdrawal. The withdrawal deadlines are strict. If you filed a request under Section 134, you have exactly 15 days from SEC receipt to withdraw. If you filed a petition under Section 135, you must withdraw prior to the publication of the order setting the objection deadline. Remember this rule. The withdrawal must be verified and signed by the exact same number of directors and stockholders that were required to approve the dissolution in the first place. Filing a withdrawal after the first week of a petition's newspaper publication is a fatal procedural error. The SEC will deny it. While the law permits a change of heart, these strict deadlines exist to prevent administrative chaos and to protect the public's reliance on official corporate filings. Now we examine the hostile territory of Section 138, involuntary dissolution. This is the ultimate state sanction, reserved for severe violations and corporate crimes. The SEC holds the power to act motu proprio, on its own motion, to terminate a corporation without waiting for an external complaint. This execution can be triggered by administrative failures, such as the continuous non-use of a corporate charter under Section 21. Criminal acts also trigger it. If caught smuggling, evading taxes, laundering money, or committing fraud, the state applies the corporate death penalty. Here is the statutory basis showing the SEC's unilateral authority to dissolve an entity motu proprio. When dissolved for illegal acts, a punitive forfeiture rule applies. After paying legitimate debts, the remaining assets are seized by the national government. They bypass the stockholders entirely. There is only one exception to this seizure. The rights of innocent stockholders and employees with valid wage claims are protected from forfeiture. The corporate veil is a privilege granted by the state. When weaponized as a front for crime, the state annihilates the entity and confiscates its wealth. Termination of the charter does not mean instant evaporation. Section 139 dictates that corporate death triggers a strictly limited 3-year juridical shadow life. This follows the 3SDE timeline. The corporation has exactly 3 years to settle its affairs, dispose of its property, and escheat any unclaimed assets. During this period, the corporation is strictly forbidden from entering new contracts or continuing its regular trade. Its sole purpose is liquidation. The Code explicitly restricts this to a strictly limited period of 3 years, purely for the purpose of settling its affairs. If 3 years is not enough to liquidate massive assets, the corporation can bypass the deadline by conveying its property to a trustee, who can continue the liquidation process indefinitely. At the end of the period, any asset left unclaimed by unknown creditors or missing stockholders is escheated, meaning it is permanently forfeited to the national government. For the bar exam, remember the Aguera Second Doctrine. Pending intra-corporate controversies remain active and must proceed despite the dissolution of the entity. A fatal error during this phase is distributing assets to stockholders before every single creditor has been satisfied. The law expressly prohibits this. The revised Corporation Code ensures that a corporation's ghost stays bound to the market until its ledgers are cleared. Dissolution is a regulated exit, preventing the corporate vehicle from ever being used as a financial getaway car.